board, and we're requesting to be on their agenda for the end of the month. January 30th is their meeting date, and we would like to give them an update on how this conversation's going and talk about that.
Then maybe wouldn't it be better then would be the motion to approve, it's denied at this point in time and they can come back later? Or do you have a time frame that we can't reapply?
No, what I'm saying is that this is on the table until removed, and I don't have a document removing it yet, the plat that's before us, right?
But if we make the plat that's before us, if we don't feel that based upon staff's input that all the i's are dotted and t's are crossed, we can make a recommendation to deny or a recommendation to approve and it fails.
It's my understanding that then if that's the case, it would actually have to go to council as well.
Right.
Correct.
So in order to avoid it having to go to council and that get declined, we would our thought would be if he just rescinds it and postpone it to the next meeting again, and then he'll hopefully by that time have that letter of rescission.
Right.
So do we want to go 2 weeks or 4 weeks?
That's the question. And I guess I'm okay with it being, since there's 3 weeks between this meeting and the next meeting, it gives us an extra week to work on those details. But my only caution, and I guess I don't think we're on a tight timeline here, but if you're willing to keep postponing it until we get something we all agree on is one thing, or
I like deadlines.
okay, I'm fine with that. I just thought I'd want to add how I think the process is going to unfold. But we'll visit with the park board about his kind of his counter offer to where we're at right now, and we'll keep discussions going, and we'll keep you guys informed with updates as often as we meet.
I'll make a motion to postpone to the next regularly scheduled planning commission meeting, which is 3 weeks hence.
Thank you. And just for the record, we'll let the record know that Liam has joined us. Thank you.
Welcome.
So we have a motion by Todd to postpone until the next meeting.
I'll second that motion.
All in favor?
Aye.
Motion passes. Item 4 is new business, meeting procedures and due process with Luke.
Yep, if you guys remember Luke, he's going to continue his presentation.
Well, hi again, everyone. Thanks for the chance to talk to you again. Today, we had, as you remember last time, we talked more about roles and issues with issuing permits, how they reflect or relate to the job that you've got, and some of the things that you want to look for as you're issuing the permits. The next 2 meetings that we have into there, the next couple of hours of discussion, involve one of two things, and one of them is specific meeting rules and meeting procedures, running a meeting all the way down to maybe some parliamentary procedure tips in which I described that, for example, a motion to postpone should be specific to it's intended to only go to the next meeting unless you have a specific thing you're looking for or you're referring it to a committee waiting for some sort of an action from them. So those are the sort of things we'll talk about in those meetings and how to make motions and run things. But I thought it made more sense at this point to talk about the due process and ex parte communication cases that we've had out there. And I know that I knew that Stonebarger was not going to be here, and I know that he sat through the last time I gave a presentation as this. I believe a couple of you did as well, but it really never hurts to get caught up on this, and we've always got a few best practices that are updated as well. So it's a real important part of your job. It's a real difficult part of your job as a planning commission and board of adjustment member, and it's one that, frankly, I don't envy. And that's why I'm happy to tell you a good way to do it and hope you can do it, because it's a difficult thing to do as you live in a community and try to serve on a citizen board like you do. But what we're concerned about here is the due process aspect of issues giving or applicants, so that they've got a fair hearing. Constitution, it comes back to the Constitution. If you want to blame something, you can blame the Founding Fathers. It states that we've got two rights that need to be safeguarded, and that's the equal protection law. That says that each law needs to be applied fairly and equal to all persons. And then there's a due process law that encourages objective decision making, and that's generally the way that we do it is we provide notice of a action, and we provide an opportunity for folks to be heard. We provide findings or why we issued the decision we did, that the people making the decisions aren't going to have a conflict of interest, that they don't already have a predisposition based on someone they know, something they know ahead of time, that the decisions are going to be made promptly, and that we're going to keep a record of that so that we know what we did a week, 2 weeks, 2 years, 20 years in the future as to how we did it. But where we run into issues with boards such as you find yourself in is the issue of ex parte communication. And that's any material that you might receive, whether it be written or oral, that is relevant to the merits of some sort of a case or some sort of a permit or a hearing that you're about to hear, that was not on the record and there was no reasonable prior notice to all parties involved. An interested person outside of the commission or the court would be someone involved, or else the commissioner or judge handling a proceeding. Those are folks that could be subject to ex parte communication. That's you, because you are a quasi-judicial board when you're handling items as a board of adjustment. As a planning commission, you're more of a legislative body, largely. Plats is maybe a little bit different, but it's still largely legislative because you're making recommendations on things. But again, the process is intended that the information you're going to hear is going to be information that any member of the public could get. And that's the bottom line. So I'm going to talk about a couple of cases where we've taken some cues over the last few years, probably the last 20 years, on some of the more landmark cases. And I'm going backwards kind of in order here. I'll start with a case that occurred in Minnehaha County. And most of these, for whatever reason, wind up being in county. Had to look hard for the Winter case, but that really is a landmark one that we'll get into in a little bit. But Hansen versus Minnehaha County Commission was a case that occurred. It was the year that we had the planners conference here in Watertown, which I believe was 4 years ago. We had one here, and I'll go through the specifics of it. But what had happened in that case was had an applicant apply for a conditional use permit to have an agronomy plant outside of Sioux Falls. Actually, it was near Baltic. And they applied for a conditional use permit. Their process is a little bit different in Sioux Falls, but we're not gonna bog down in that portion. But the conditional use was for, as we said, an agronomy plant. They have farm chemicals, anhydrous ammonia. Think Hefty Seeds is probably a good example of what it was. It was not Hefty, but it was similar to that. But there are several worried neighbors that testified at both the Planning Commission and then during their appeal process as well that they had. So there are several people that testified at a hearing. An interesting thing that went on, though, is that they have, with their board, there, of course, is they've got an appointed body with one county commissioner that sits on that board. And the county commissioner, having been living in the city, really had no idea what an agronomy plant really involved, what the herbicides were, what the safety procedures were, how they handled things on the site. So what he did is he lined up a tour, go check out a different plant. So he went to another plant. Now, one of the things that he ran into trouble with was the fact that, and he said in his deposition that he was not aware of the fact that the plant he did go to was owned by the people that made the application. That was brought up, obviously, at hearings that was improper. But the point is, he went out there, reviewed the site near Worthing, and after having been there, he felt like he had a better feel for it. When they came to hearing and talked about the issue or the request, he had, as we said, he knew about safety procedures, and he made that note during the hearing that I went to the Worthing site. I viewed these safety procedures. I now feel more comfortable with this. And at that point, he was comfortable voting for the permit. So that's just what he did. And in that, they wound up, that was one of the key points of contention as that was appealed to circuit court. Now, when it went to circuit court, one of the arguments, there were several arguments, of course, because, and again, this board hasn't seen many cases referred or challenged to circuit court, but in our experience, at least of late, I believe one of the documents we had asserted 21 things that were wrong. You'll see many things that'll be listed as far as points of issue, but one of the things that was brought up, and one of the key points, was that idea of bias that he had already had because he went and toured this plant. And you see up here, I've listed the 4 forms of bias that are based out of cases not only in this state but also other states as well. But they're more laid out in the Hanig versus Winter case I'll talk about in a minute. But there are 4 types. There's direct pecuniary interest, which is when you as someone on the board can get money. You benefit directly monetarily from the vote. There's indirect pecuniary interest where someone you know, an employer, someone that's closely tied to you, may financially benefit from the request. There's direct personal interest, and that's where there's a blood relative or someone of great importance to your family, maybe even yourself, is the one making the application or is directly involved in whatever that application is for. And then there's the tricky one, which is indirect personal interest, which becomes a case of great difficulty because part of the reason you're on this board is because you know a lot of people, you know the area, but the bottom line is that it's where in an individual's judgment, your decision may be affected based on your membership of an organization, a friendship, so on. And we'll try to narrow that down and make things make a little more sense as we go through this. In this case, though, what happened was at circuit court, the circuit court held that Commissioner Kelly's visit to the agronomy plant to go teach himself more about agronomy was a violation of due process of the neighbors. Hanson is the neighbor in this case that brought the suit. And so because he did not notify the public that he was going to that site to learn more about it, he violated the due process of the public in that case. The court found that he took evidence outside of the record, and that's where the issue was. And so he not only did he take that evidence, he relied on that when he made his decision. They did say there is no personal motivation to his bias since he was just visiting to learn more. However, they found that, and this is a key point here, they found that the very appearance of a complete fairness was not present because of his site visit and the ex parte communication. So the point is that it led to an appearance that he may be biased. And that was really all they had to prove in that case. That's what the circuit court contended. So Minnehaha County did what I would have expected. They appealed that to the Supreme Court. And I'll tell you, as Planners Association, we were watching that very closely because we want to know, for your own sake, as a planning board member, what's this mean? Are you not allowed to drive by a place? Can you not go wander around? Can you not go talk to the person who's made the application or walk up to the house? And Supreme Court punted on that question. Basically, what wound up happening was they ruled on the portion of the arbitrary decision and said that, and this is relevant though in different circles here, they ruled on the arbitrary, whether or not the decision was arbitrary, because they said that there are only general statements in the ordinance with regards to their case. This is just kind of a sidebar here. But in their ordinance, they just had the same things you have, the ingress, egress, the signs, the compatibility, those sorts of things that are within most ordinances. They had similar, and then within their land use plan, some general policies. And they cited that those were the board had cited those as reasons for issuing the permit, and the Supreme Court said that was good enough. They referenced those as long as they touched base that they had met those criteria that were established, as vague as they are. That was fine. But the part that was more interesting, that's the part that the Supreme Court ruled that they didn't have to rule on because with disqualifying Commissioner Kelly's vote, the vote still passed. So it was really moot. And so they didn't really have to decide whether or not he actually needed to be involved. So ultimately, the decision by the Supreme Court was to uphold the permit, not based on anything Commissioner Kelly did. It was basically because they already had enough votes. They didn't have to follow through. So bottom line is, all that to tell you that we're really a little bit more confused based on that. So that's why we give a couple more cases here to give you a little more context.
Luke, it would have been different if they would have denied, though. They probably would have had to take a closer look at that.
That's exactly right. Had that vote being disqualified led to a denial, then it would have been a bigger problem. I mean, then they would have had to have specifically looked at it, as you said. I just want to make sure. One of the things that was within theirs, and that was one of the things that the Supreme Court latched onto, was there was not a specific number of votes that they needed to listed in the ordinance that they had to have. But bottom line was they had the 4 votes they needed at that point. So that was the bottom line. So one of the cases that was referenced many times throughout that was a case that, again, as I look at this, it's entertaining and interesting to me to look at some of these rules, or some of these rulings, which may tell you all you need to know about me. But the bottom line is that this case itself is one that gets referred to a lot in any sort of ex parte communication case. It's a case out of Winter, in which it deals with a liquor license, so it's a city council issue that was issued, but it really lends itself to decisions that you make as well, specifically since it's a license process. So in this case, what had happened was a liquor license renewal was applied for by a steakhouse and lounge to the city council. But one of the council members was a waitress at a competitor's steakhouse. And the council member's boss spoke to her and wrote letters to the board and to her, urging them to deny the liquor license. And then the city denied the liquor license. And so I kind of fly through how this went, but I actually took a little bit specifics in some of the decision that was made. The Supreme Court reviewed the due process question and said that an individual's right to due process does include fair and impartial consideration, and that's where the basis for some of these things comes from. Not only is a biased decision maker a poor, constitutionally unacceptable, but our system of law has always endeavored to prevent even the probability of unfairness. And again, there you go. It's a probability. It's not necessarily the fact that you had a motivation. It's that the probability was there. So basically, off of that decision, what we find out is that in order to show that you're biased, it's more about the need to show an unacceptable risk of bias, not necessarily the bias itself. And that's where, as you have these conversations or you hear from people out there, you think about, how's this look? Which it's the sort of thing you'd try to tell your kids not to think about what other people think about you, but in the same breath, when you're doing this, you actually have to think about what people think about what you're talking about. Yes. A couple of points in here that were key that I take out of that get referenced a lot is that the Supreme Court saying that regarding conflict of interest, that officials need to disqualify themselves when they have business or personal interest in the subject where they're voting, regardless of whether the interest creates an actual bias. And this gets pretty nitpicky into some of this as it goes on, and I'll kind of back some of this away. If they show there's a capacity to tempt the official to depart from the duty and instead to serve their personal interest, that's also the key risk in the actual bias. And then they quoted the Iowa Supreme Court, which that's where a lot of those 4 points came up that I talked about, the direct pecuniary interest, indirect, and so on, where that came in. And it comes off of common law into there to show that you don't have ill will towards someone or you don't have the opposite, preferential treatment. So when can you vote? What came out of it is the idea that the interest must be different from that which, for you as a board member, than a general member of the public. So do you have a different interest when you're issuing this permit or than everyone else? Is it unique to you because of a family member? Is it unique to you because of a friend? Is it unique to you because you receive money on it? But not only that, is it unique because you got information that you would not have been able to get as a member of the public? And that's where it goes back to the case in Minnehaha County. Was the idea was that that board member was getting information that he would not have been privy to had he not been a board member. They're arguing essentially that he would not have got in the tour, or they may have told him things that they wouldn't have told other folks walking through there. So, and in the end, it was really hard to argue either way, to be perfectly honest, because no one else was there. So that's where it's more about the risk. However, it does say in here that interest does need to be direct, definite, capable of demonstration, not remote, uncertain, contingent, unsubstantial, and so on. So it doesn't need to be something that's demonstratable in some way, shape, or form, but it's kind of talking out of both sides of the mouth, but it's more about the risk that you have to be able to identify. So again, you go back into it, the types of bias that you're having to argue against, whether or not you have, and then leading into that bias case, that's where Hannah really leads into the bias and less with the ex parte communication. And so what they argued is that she actually had an indirect pecuniary interest because her employer was going to stand to perhaps make more money if this other place didn't have a liquor license. And so, point made. So in that case, they needed to hold a whole new hearing. They disqualified that particular council member's vote. And so the other point that was important is that council member didn't disclose that point, the fact that she worked for the other steakhouse in town before they made the vote, and that she had those conversations beforehand. And so that made it very easy for them to argue that she had conscientiously withheld information that may have affected the ability or the idea by the applicant that this person may not be competent to vote on it. It comes back to some of the decisions and actions you make where you have had, or you've got something that in the back of your mind you think, well, maybe I should bring this up, maybe I shouldn't. Basically what it's saying in here is that you're probably better off to bring up that point, and if that winds up being something that it's really up to your board, ultimately your chairperson, it's up to whether or not you feel like you need to recuse yourself, but it never hurts to talk to your attorney ahead of time too, just to verify that point.
I got a question on that, Luke. So,
Sure.
So the applicant could, so if as a board member you recused yourself, the applicant could say, no, you don't have to recuse yourself. I trust your judgment. Is that what that's saying? With the applicant or petitioner giving the opportunity to weigh the nature?
It's essentially it's the antithesis of what I'm saying there, obviously, because what in that case they're saying that the applicant should have had the opportunity to say, I'm okay with you on this board in that case. Ultimately, the decision does come with the board to decide whether or not they feel like that person is. But it does need to come down to you as well. If you feel like your relationship or your past information you've gotten has predisposed you already, yeah, you need to disqualify yourself right away.
And generally, wouldn't you agree, Luke, that it should happen prior to you get into the public discourse of the public hearing? Talk to this attorney. If the attorney says it's your decision to make, if you think that you can still be unbiased in your decision making, you should still disclose it. But at the same point in time, does the board have the ability to censor a person if I disclose something, I don't think it's a problem, but the other 4 or 5 think it could be a problem?
They do, and I'll go through with some best management practices as far as their best practices, how to handle that throughout a meeting, and we'll probably double over that at next meeting too. But basically, what you want to do is you want to point that out. What you need to do is you need to point that out ahead of the actual motion on the item, or even any discourse at all. I forget that you don't do a motion before you start talking. But the point is, before it's even brought up, you want to point out, I had a conversation about this. I know that the applicant is my third cousin, but I perceive no monetary and no conflicts here. This will not affect my judgment ahead of time. Let's say that you make that point. Let's say that Blake makes that point. But there are, one member says, you know what, I disagree. You do know that person too well. This may be a conflict of interest. You can ultimately, they can make a point of order to the chairperson. Chairperson says, makes a decision saying, you know what, Blake, you're right, you're fine. If that person who disagreed wanted to appeal the decision of the chair, they can do that. So they make an appeal. They make a statement, say, I appeal the decision of the chair. If there's a second, you can actually discuss that, why. There is the allowed discussion. But then the board can vote on whether or not they feel like Blake is predisposed to make a decision in that particular case. And so it does allow, through parliamentary procedure, you do have that ability. So bottom line is, yes, you can, and then I'll point out procedurally when the best time to do that here is at the end here. So back to this case, the point that's said in here, and I see where you're going with that, Blake, is that if the person doesn't bring that up during the hearing, then it really falls on the applicant to point their finger at, hey, you're not qualified to do this, when they don't know what happened out there. And so that's their point, is that that's not due process. I don't know all of the factors that are involved in this ahead of time. So that particular case was again used as a basis in another case that wound up being an ex parte communication case. I kind of want to see my time here. I do have to get on the road at some point here, but it looks like I got time. One of the another case that occurred, and this is another county case. It occurred in Turner County, and it was approximately 10 years ago now already. In this case, it was a zoning officer, also a zoning officer. It was the finance officer and the zoning officer and several other officers at the same time. It was the same person. Had mistakenly issued a building permit for a elevator. Come to find out, needs a conditional use permit. Oops. So, they informed the elevator, sorry, cease and desist, you need to stop because you need a conditional use permit. At this point they had, and I don't remember the dollar value, but it's somewhere in the neighborhood of, I'm going to throw out $100,000. I think it was somewhere in that amount that they had already spent on this and gotten going on. That's not counting engineering, and they already had a couple bins up, if I remember right. So they applied for the conditional use permit. No big deal. We'll go back. We'll get it straightened out. Well, there's some neighbors there that didn't like it, and they made a pretty good case, so the board said, no, you're denied. Well, now what? So what happened was they did not have a provision that said that they had to wait 6 months in their ordinance. They got to come back, and they could just, through attrition, keep on asking. And so they asked again. They amended their application because the board did do one thing within it that is within the findings. They did point out, here's why you are denied. And they had a couple of reasons. And so what they did is they addressed those reasons, and they came back and they reapplied. Now, there's a new board member that was on that board, and in between the denial and the next application, that new board member had taken upon himself to try and mediate this issue, and talked to the neighbors on the one side that didn't like it, and talked to the board or to the elevator to try and get things straightened out, and how are we going to bridge this gap? And he did make it known, because he also was a county commissioner, he did make it known that it was his goal to try and help save the county some money, because they knew that they'd probably be out some money in the lawsuit if they wound up losing this lawsuit. And so that board member had been involved, as I said, in those mediation. He had pointed out that he was trying to save the county money. And then the hearing came, and he testified, talked a little bit about that. Then he made the motion to approve the request. Then obviously he voted in favor of the request. And the board did ultimately approve that request with some conditions, and the neighbors didn't like it. And so they filed a petition in court. Oops, let's come back to here. So the Supreme Court looked to administrative procedures and found bias that the commissioner should have disqualified himself, given the fact that he had pointed out he was trying to save the county money. He had already talked to both sides outside of public hearings. In some cases, it was individually. In some cases, they were in the same room. And so his motive was different than that of a member of the public. Particularly, his motive was that he was trying to save the county administration money because of a potential lawsuit. Chief Justice Gilbertson, who at the time of the Winter case, and I did not bring this up, at the Winter case, before I read this part, he stuck up for you guys on the board, is what he did. He was actually the dissenting vote in the Winter case, because the point that he made was essentially that when you live in a small town, Justice Gilbertson's from Sisseton, he said that you can't help but know somebody that's making an application. You will never be involved in a decision if you disqualify yourself because you know someone who knows someone, or it's a third cousin, or I've known people that have said you can't throw a rock in the county without hitting a cousin. And the bottom line is that it's almost true in some cases. Maybe not necessarily here, but it's not that far off for some. So the point is that you're never going to be able to make a decision if you got to bow out of everything. And frankly, part of that fact that we are so close knit and we do know people, and we're related to some people, is part of what makes us qualified to make the decision, because everyone else does too. So that was maybe taking a little bit of liberty of what his statement was, but the bottom line was that they've got to have some leeway. In this case, he was a little bit harder on him, but said that in the case of Hanig, he created an unacceptable risk of bias when he was serving in the other capacity. So in this case, any reasonably minded person would be able to point out that he had another motivation. Whether he was voting with that motivation or not, although he had kind of made it clear that he was, he had already influenced his impartiality. So he really had no prayer in that. So the point was that in that case, they had really gone above and beyond to point that out. So in that case, the decision was reversed and it was remanded back to the Board of Adjustment based on a violation of due process. And it was based on the idea that the board member had orchestrated a plan to avoid a lawsuit, and then voted as a member of the Board of Adjustment to put that plan into action. Again, you have the ability to put a plan into action when you sit on a board like this. And so I'm going to stop there with the ex parte portion and just kind of talk through how some of that affects yours. And I'm not going to get into this part about disqualification of votes at this point, and I just want to talk about how to handle your jobs. And a lot of times when I get done with this presentation, boards look at me and say, well, thanks, Luke. How the heck am I going to do my job now? A couple of things to keep in mind, and an example that we use a lot is that when you think of yourself on the board, you're the judge. Okay, so I mean, if you were out and you got a ticket for whether it's reckless driving or speeding or what have you, and you got a court date that you've got to go into, and you're planning on fighting that ticket because for whatever reason you decide you weren't speeding, and you go out on Saturday night to whatever place you go out to on Saturday night, and you see the judge that's scheduled for sitting at the same table as the deputy that pulled you over. Now, it's likely they weren't talking about you, but that's not what you're thinking when you go on. And so the point is that you've got to keep that in mind as you're going out and doing your job as well, is that you're the judge in these cases. And so it doesn't mean you can't go about living your life, but an example that I often hear out of some board members have told me that it's, even though it's harsh and it's difficult to do, what they've said, the thing that they'll use for an example is someone calls you and maybe they lead into the idea talking about it, or you know that they might be involved in it. The one thing I've heard individuals say is that They'll answer back, listen, we've known each other a long time. We'll talk about our kids. We'll talk about the weather. We'll talk about crops. We'll talk about anything, but don't talk to me about the request today until it's done, because anything we talk about could only hurt the case. And so the bottom line is that if someone approaches you about a topic outside of a meeting, ahead of a meeting when you know an application is coming, the absolute best thing you can do, and I know it's unavoidable in some cases, don't get me wrong, but the absolute best thing you can do is direct them toward your staff. If at all possible, try to direct them to your staff, and the best thing to do is to convince them, if they possibly can, to put it into either an email or a letter, or if they want to just talk to staff, they can, but to put that into there, and then it can be read or pointed out at the hearing itself, that information, whatever information they've got to say.
Or make sure that they show up at the meeting.
Well, that would also be good too. But the point is, I know it's difficult, and you are going to wind up in cases where someone has talked to you about an item ahead of time. But I just kind of want to talk about a couple of things to wind up doing here. And as far as how to handle that once, oh crud, I may have stepped in it, I may have talked to somebody, I may have gone out there. What you do in a case, if you're not sure, and we'll go back to what our conversation was a few minutes ago. If you're not sure if you have a bias or that you've had too much ex parte communication, work with your attorney first. Make sure and talk to them. Let your staff know that you've had a conversation or that you may have an issue, and talk about it beforehand so that you know whether or not you need to point that out. But the main point is you make sure that you point that out ahead of any discussion on the item. Because if you're seated up there and you involve yourself in the conversation, and then before the vote you point out, well, I'm going to abstain now, or I need to recuse myself because I already talked, well, it's not to say that you did, but you may have directed the discussion throughout it, and you really don't know at that point. So the point is, it's way better. It's the best practice is, before it even comes up, to point out, on Thursday, Mike Smith called me about this issue. He had pointed out a couple of items. I don't see Mike here, but I had suggested that he come to the meeting. Those items he pointed out were these two. I don't think that predisposed my ability to make a decision on this topic. And then that's where I said, if somebody waves the flag on you and says, no, you did too, well, then you guys can go through that parliamentary procedure style to figure out whether or not you did or not. But once you have, let's say that you did. The other example is you'd point out that I did have a conversation with someone and I got too far into that conversation. On Thursday night, I was out at an event and the applicant was there as well, and we got into discussions and we discussed this matter too much, and I feel it's predisposed my ability to make a decision in this case, so I'm going to step down. And so you get up, walk over, sit in the audience, and watch as that goes on. And
The good thing is that we have alternates to the board. So if you even think that it's a possibility or you don't feel comfortable, regardless of what the advice of the attorney is, if you still don't feel comfortable participating, make sure staff knows so that we can have somebody here to fill those spots.
That's true on the Board of Adjustment, not true on the Planning Commission.
Right. I think we're a little bit on the Planning Commission on the one end of it, though. What we want to do is we realize that we also recommend, and we only need to have 4 for the quorum anyway, so we can make it. Well, it will work both ways. But I think on the Board of Adjustment with the alternates, it's really important to, if you feel that you're gonna, you don't want to be deposed over that.
Yeah, the one of the questions Brandy had asked and a point that's made is that you do keep in mind the hats that you wear, though. I mean, you've got your Board of Adjustment and your Planning Commission hat, where you serve as a Planning Commission member. Obviously, there's some legislative aspect of it. One of the things that's been brought up before is that if there's an issue or an item, why don't we allow, I don't know what, in the residential district, it's something that could be brought up to a planning commission member. But once there's a request or a hearing scheduled or a discussion on that item, that's where that conversation outside needs to stop about that topic. Once it's been voted on by you, all right, now everyone can hear every idea you've had, and I bet there will be less people interested once you already told them at the planning commission meeting. But the bottom line is that when there's an application pending, that's when you need to close the blinders a little bit more and do that. And like I said, I know it's difficult. I mean, but no matter where you're at, you're going to get brought up on it. The point, back to what was made by Mr. Kays, what you were talking about, is that that's one of the things I wanted to point out specifically, is that as you're a board member and you're sitting up there, especially on a board of adjustment item, and you're not sure if maybe I do have a conflict of interest, think about the fact that you're probably staring right at an alternate that doesn't have a conflict of interest. And so is it better to maybe have a conflict or let that other person come up? And that's where, like it was said, have those conversations before the meeting, especially because that helps to ensure that there will be an alternate there and whether or not you feel comfortable doing it. With the planning commission items, and that was a point that I was leading into, one of the things, and I'll make this point to staff as well, that I would suggest is that if you do start to have more of those issues where you get more written comments and that sort of thing, one of my recommendations is that I will oftentimes, especially if it's an issue like a legislative item, if it's a planning commission item where you're recommending approval of, say, whatever ordinance to allow this or that, oftentimes I'll suggest direct those towards the staff, have them have written so that essentially, and then staff, you can tally. I received 27 phone calls, 13 were in favor of it, 14 were opposed. Of the 13 that were in favor of it, they cited reasons for this reason, this reason, this reason were reasons that they had, citing for approving it. Of the 14, here were some reasons that they had in opposition to it. I do have record of all of those, and you keep a record of anybody that did talk to you. I have record of that if anyone wants to review those. However, the summary this is a summary of what I had heard from it. And that's an example of that. One of the other things that I've seen is where a board member got emails sent to them, and immediately my suggestion on that is if you get emails sent to you, forward them on to staff is the best thing to do.
What about, Luke, sometimes you and I hear this, but you've got a board member who doesn't know anything about agronomy. He doesn't go visit the site, but he decides that he's going to use this thing called Google and to get educated. Does that predispose somebody, or, I mean...
At this point, based on what we know, and it becomes more of a legal question, but the bottom line is, in the experience that I've got and the experience that we've seen around, you go back to that point that was made about, do you have access to something because you're on the board? And I'm going to tell you that most people have access to Google. So the bottom line is, unless you don't know how to run your computer, which there are those. But the point is that if it's publicly available, it's free game. So that goes back to, how do I do my job if there's an application out there? Because, to be honest, in a lot of cases, you're on the board because you're naturally inquisitive. You like to know what's going on in your community. And I'm betting the bulk of you probably drive by a site when it's up there. At the very least, you try to know as much as you can. Based on what we know of this, it's not like for once the application comes in and the site is between you and work that you have to take a different route to work it. No, that's actually the whole point, is that if the information is publicly available, for example, if you can see it from the street, the right of way, park on a street or something like that, it's probably all right, given that it's publicly available information. You want to stop, park there? Yeah, that's fine. Once you get into the point where you're pulling into the yard, you may even be able to pull into the driveway, into the parking lot, and look at that information. But once you see someone walking out at you, now you don't squeal the tires and run away. That's just creepy. But the bottom line is that you need to avoid those instances where you might get specific information. And at that point, you're just going to have to friendly wave and have to be on your way. If
Don't
you
roll
did do
don't
that.
roll the window down and say, "Hey, come over here. I want to talk to you."
Yeah, exactly. Once you get out of the car, you're really treading on thin ice, is what it amounts to.
Luke, just a quick question. If some of that activity happens where you get in too deep to the conversation before you realize that, I think one other option is to make sure that person comes to the public hearing or comes directly to the whole board and restates their case. That can eliminate, as long as all the discussion is before the entire board. Does that help the discussion or not?
It's probably the only way to try and save it. However, you go back to the question of, is there the perception that an unacceptable risk was occurring? And that's the bigger concern if you do that. So that's probably the best way to try and save it, but it's not going to guarantee that it's going to save you. This best practices slide came out of how do you handle a case where you need to go on a field trip or you need to gather more information. And here's the first point. Once an application's made, don't go on a field trip. That's probably the best way to do it. But there are ways where you can hold a planning and zoning commission meeting. You can hold a planning commission meeting somewhere else. There's nothing against holding a meeting somewhere else, but it's a meeting. It's a public hearing. It's a public meeting. So you're gonna have to post it. You're gonna have to post where it's at. You're gonna have to post what's going on and the topics, and that it will be a part of the discussion. And the problem is that when you're on a tour, unless you're walking around like this, almost holding hands, wandering around there, you can't guarantee that one board member didn't hear something different. That's why it's advisable. Don't do that.
And especially don't go if the applicant's paying for the bus ride.
That's another good point. That if you're getting the free tacos or what have you out there, that's something to avoid. Again, before there's any sorts of applications or any questions on that matter, that's fine. Or afterwards, that's fine too. But I think the tacos you're probably going to be paying for your tacos after that. Just a couple of things. I'm not going to read all of these to you, but again, you ask yourself and your state's attorney if you feel like you do have these conflicts of interest. Is my potential conflict different than any other member of the public out there? Make sure you disclose it. And one of the items that's out there, and I suggest this where we go, is that you offer the applicant the opportunity to request the matter to be acted on, postpone it, withdraw it, pending the information based on it. They've got a clear vision of what's going on with the board. They know that this person's there, and if they've got a problem with the fact that you may or may not have a potential conflict, then they can address that at that time as well. And so they can request they handle it differently, and then it would be up to the board as to whether or not they want to honor that or not in that case. But again, I typically in that case, and then also in cases where you have, say, a board of adjustment, you've variances, you have to have 5 votes. Be my recommendation, even if you don't have a conflict of interest, to offer that up to the applicant as to whether or not they would rather have the matter postponed, knowing that they need to have everyone vote in favor of it. And I think you do that by and large, but just it's a good practice to do as you go into that. Same thing on a rezone or something like that. And so with that, I'd be happy to wax poetic about any anecdotes you've got regarding this, or if you've got any questions based on it, go ahead and shoot.
In terms of interaction between board members outside of a meeting, at what point do we have to provide notice? What interaction can, say, Mr. Hanson and I have, or something like that? I mean, obviously, there's pleasantries, but what about applicant processes?
No, basically, it's a good question. As far as an application, none. That's the bottom line. from your own personal standpoint, then it's your own. I mean, you're going to have to use your own conscience on that. But the bottom line is that with regards to an application, your conversation goes through your staff, and so it's very much like a bad TV show. You tell Shane, you tell Jason that I said this. And then Jason says, you tell Liam that I said this. And it goes back and forth. But the bottom line is that you really can't be having conversations about any issue that's going to be before the board unless it is here. I've got a slide that I use in some of my other meetings that has a cartoon that says that on it says, I'll accept a motion based on the email that Steve and Judy talked about at last night's picnic. And so basically, it's bottom line is that anything that might possibly based on a conversation that you had before is a no-go.
Luke, so, but they can come and see me because they could all do that, right?
Individually.
Yeah, individually, yeah.
Yes.
So it's quite often somebody will come and talk to me, so Ken, what's the background on this?
Yes.
But since I'm available to any one of them to come and ask me that's all right?
They can come in individually, yeah.
Yeah.
As long as you're not going to have more than one at the same time. So you kind of watch that, or else you might get to have yourself a chair out in the waiting room until Ken's done with the first one. But yes, they can definitely come to staff, and that's the whole point, is that if there's something, you drive by, you go to a site, and you look at it, and you're curious about something that you'd like to know more about, before you go knock on that door, think about the idea that you know who really can knock on that door. It's Ken, and it's Jill, and it's Brandy, and it's your staff. They can go do that. They can take the picture. They can take the notes. They can bring that to you. You're able to do research on the topic. It's just got to be information that's publicly available. And if you have a question, chances are someone in the public has the same question. And so it makes perfect sense. And that's why you ask your staff to go find out more information about it. Otherwise, you're just blindsiding staff. You're not supposed to enter the room blind with blinders on either. That's a good question.
Yeah, and for that matter, research too. So in cases of ordinance, that's one of the common themes, right, is to ask staff to maybe provide some research on what other communities are doing.
Yes.
So.
Yep. Anything else for me? Well, then I will fly to Brook.
Thank you, Luke.
Thanks, Luke.
That brings us to old business.
I do have one item of old business, just an update. The city council did pass the modifications to the Gateway Overlay District as provided or discussed by the Plan Commission. However, there was an additional directive, and that was to go in, and we are being asked to prepare some additional clarification language in there. And so staff will be doing that, and we'll probably have the same small committee meeting that met with the other changes. We'll briefly run those by them. You'll eventually get something back, but they did pass it the way the Plan Commission also recommended it, and so that will be the law of the land until these minor changes come forward. But they decided to pass it as is, and then readdress the minor issues. So there's not big issues out there. It's just small stuff. But just I'd let you know that you will see something from staff again.
And it wasn't over the percentage of metal either. You guys got that ironed out?
Good deal.
No other old business.
Okay, thank you. Executive session? No need? Motion to adjourn?
So moved.
Second.
All in favor?
Aye.
Thank you.